Hey everybody, how are we doing today? Contrary to popular belief, I am not dead. So from Reason.com, Free Minds and Free Markets, South Carolina judge rules the obvious. It's unconstitutional for police to seize and keep people's property without proving they committed crimes. Yeah, it is pretty obvious. It's literally enshrined in the Constitution as law. Law enforcement prosecutors have seized millions from people they've arrested that might be coming to an end. Thanks to the chronic abuse and misuse by local police departments, the days may be numbered for South Carolina's forfeiture system that allows cops to seize and keep cash and property of the people they arrest in order to fund their own departments. Circuit Judge Stephen H. John has ruled that the South Carolina civil asset forfeiture regulations violate the 5th, 8th, and 14th Amendment rights of the citizens. Civil asset forfeiture has been in the crosshairs across the country for years now, because it allows police and prosecutors to declare that any money or property owned by a suspect is connected to a crime and seize it, and then ultimately keep it for themselves. And because this is a civil process, police and prosecutors can do this without having to convict anybody. It's the assets that are considered the defendants in this case. The respondent is actually the $2,771 that Horry County wants to seize from a man charged with trafficking cocaine. Prosecutors typically have a lower threshold to make their case than beyond a reasonable doubt, and people who are pulled into these forfeiture cases don't have access to public defenders and have to find their own lawyers. The end result, police trying to keep whatever they can grab off of anybody they arrest, claiming it's all proceeds and property connected to criminal activities, and using it to line their own pockets. This incentivizes police to look for people who have assets that can be seized. Local newspapers in South Carolina teamed up to investigate the extent of abuses and discovered police agencies across the state had seized more than $17 million in assets across 3 years. In 1/5 of the cases, nobody was charged or even arrested for a crime. Nope. They can literally just decide that you have a large amount of cash and therefore you must be involved with a drug trafficking scheme or a pyramid scam. And then they can just take your shit. Their favorite victim being black people, of course. Because, they've been getting away with that shit for years. Sometimes even no racism needed. They just overlook it. That's largely because black people are overrepresented in crime statistics. Massively. Some even claiming that it's at least partially artificial. But Judge John notes all of these problems in a decisive ruling that smacks down the practice of civil asset forfeiture. In his 15-page opinion, he writes that South Carolina's forfeiture practice violate both the U.S. Constitution and the states because the statutes, one, place the burden on the property owner to prove their innocence, unconstitutionally, institutionally incentivizes forfeiture officials to persecute forfeiture actions, and 3, do not mandate judicial review or judicial authorization prior to or subsequent to the seizure. He also notes that the statutes violate citizens' 8th Amendment protections against excessive fines. South Carolina asset forfeiture system is particularly terrible because 75% of the seized assets go directly to the law enforcement agency that seized the property, while 20% goes to the state solicitor's offices. The prosecutors. The money seized goes directly to the people trying to seize it. The money seized is supposed to be used solely for drug enforcement activities. But John observes that this restriction has very little oversight. Law enforcement ends up approving spending above and beyond what their agencies have budgeted, with the understanding that they'll make up the difference from seizures. That doesn't even get into the issue that tying a police department's budget to proceeds from fighting the drug war warps their priorities to such a degree that they're not focusing on crimes that have actual victims. Later in the ruling, John painstakingly goes through a checklist to show exactly how the state's forfeiture system leads to bad incentives and a cycle of revenue seeking. Forfeiture revenues in each agency are directed to a designated special revenue fund. These funds are used to pay expenses directly associated with the program. These funds are used to pay for discretionary items that would otherwise be unavailable to law enforcement agencies. The funds are used to pay for recruiting expenses, creating a secondary budget with each agency that is not subject to legislative approval, and that results in agency dependence on forfeiture funds to continue paying those expenses. The existence of forfeiture programs in each agency depends on the revenue generated by forfeitures. Forfeiture revenue is used to justify the salaries of forfeiture officials. Declines in forfeiture revenue may require the elimination of positions of forfeiture officials. Declines in forfeiture revenue would require the elimination of significant direct discretionary spending by each agency involved, and, in practice, officials involved in the forfeiture program control how forfeiture income is budgeted, and spent with little or no oversight from the legislature. We have to find more money to seize or our budget will run out and we'll lose our job is not a model for a policing system that is focused on fighting actual crime. But the fight to reform South Carolina's system is far from over. The decision doesn't extend statewide, and Horry County's solicitor's office has filed a motion asking John to reconsider his ruling, noting that, among other things, the defendant in this case pleaded guilty to the crimes and the seized cash is worth much less than the potential maximum fine of $50,000 he could have faced. Writing at Forbes, Nick Sabilla notes that in the wake of local reporting about the expansive abuse of asset forfeiture in South Carolina, lawmakers attempted to pass a bill which would have limited civil forfeiture entirely. It stalled due to some technical issues with the wording, but Sabella expects a revised version to return in the next legislative session. If it passes, South Carolina would join New Mexico, Nebraska, and North Carolina in completely eliminating civil asset forfeiture. A conviction would be required in order for police and prosecutors to try to keep somebody's cash and property for themselves. It's unconstitutional, and it encourages the behavior. It really does. And what if they're spending that money to buy shit like pool tables and Pong? Or something of that nature. It's too easily abused, and it's unconstitutional. Judge John's conclusion and judgment is absolutely correct in this case, and should be respected. But you know what they say about prosecutors. Those are usually the ones who are really, really super corrupt anyway. They mostly just care about winning trials. And they have a direct relationship with the police. So you really can't trust prosecutors a lot of the time. The judge's decision is absolutely correct. People's lives and dreams of their future have been shattered by this practice. Some people even live in fear that they're going to get civil forfeitured just traveling from point A to point B in some places. The police need to be held to a higher standard, or they simply cannot be police. And the fact that civil forfeiture was even instituted in the first place, another unconstitutional law that got passed anyway. This is not the America our founding fathers wanted, even close to it. It bears a passing resemblance only. And that's only because politicians have guaranteed that it does. This is just another authoritarian state, just like everywhere else, and this only serves to prove it. But what I want to see, more than anything, is the money stolen from those people returned. I don't care how it happens. If you have to arrest a bunch of cops, then so be it. If you have to fire a bunch of them, so be it. Those people deserve to have their money and their futures back in their own hands. Personally, I think police departments should be subject to civilian oversight. But currently, so to my knowledge, they are not. But they should be. Every police department should have like a Frank Serpico situation, where they call them out on their bullshit. The policing system in this country has been off its rocker for a long time now. All kinds of abuses have taken place. The police are basically corrupt. I mean, any black person who has been a victim of racism should know that all too well. And amazingly, even a lot of white folks have been shot just because they at least appeared to be reaching for a gun. Like, he's reaching for his waistband. Which could really be anything. Maybe his belt just falling. That's kind of an arbitrary assessment as to what counts as I fix my hair, as what counts for a reason to think the guy's got a gun. Bottom line is, the way I see it, if you do not absolutely confirmably see something that you know is a gun, then you can't shoot. You cannot shoot. You can keep your gun trained on them. You can tell them, like, freeze, put your hands in the air, keep them where I can see them. But you can't shoot. That should be the standard. Period. But, who's going to listen to me, right? I'm just the voice of reason, and people don't like reason. Especially nowadays. Anyway, peace!